So we are going to be looking at criminal law this afternoon. I'm going to give my attention to the fundamentals of criminal law, and I hope by the end of this lecture you will appreciate the topic. Of course, first and foremost, I need to introduce myself as the instructor for this module. My name is Ivan Mugabe, and I'm of course an assistant lecturer in human rights at Kabale University. And of course, my focus today will be on 3 areas. 1, I'm going to look at the sources of criminal law. That is going to be one area of emphasis. From there, we shall look at the nature of criminal law. That will be area 2 of emphasis. And finally, we are going to be discussing the principles of criminal law. Now, of course, it's a topic which you'll definitely agree with towards the end. That is a very passionate topic. Now, first and foremost, in as far as criminal law is concerned, we shall start off with the sources of criminal law. These are mainly 4. And I will endeavor to see that I extensively and elaborately explain each of them so that you appreciate and understand the context. Now, the very first source of criminal law is the Constitution of 1995. Now, I need to be very specific that here I'm talking about the Ugandan Constitution. Of course, there are many different constitutions across the globe, but at this juncture, we are reflecting at the Ugandan Constitution. Now, in as far as the Constitution is concerned, the most important article, it is Article 28. There are many other provisions, but in criminal law, I will ask you to, in your free time, to go and look carefully at Article 28 of the 1995 Ugandan Constitution. Now, of course, this gives us the background of criminal law. It talks about a range of things, the right to defend yourself. It talks about, of course, principles of not to be punished twice for the same offense. It gives us the concept of retrospectivity. So I would actually encourage every student in first year to endeavor that you look at the entire Article 28 of the Constitution. Now, of course, from there, we have source number 2, which is case law. Source number 2 is case law. And of course, this is also very, very key. It's also very important because it helps you to understand and also appreciate certain key principles. Now, I'm going to break this a little bit further. What do we mean when we talk of case law? There are different cases. And all these cases are very important. Now, cases are decided by courts of law. Let me make that a little clearer here. But in criminal law, there are cases which relate to criminal law. Now, when we talk of cases, some of the cases may relate to contract, others may relate to tort, others may relate maybe to administrative law, but we shall be giving our special attention to those cases which are mainly relating to criminal law. And this is going to be very, very important. Now, of course, here we shall be looking at some of the cases, like, for example, the case of R versus White, which I will expect you to read in your free time. That is a decision of 1910. You'll find it in 1910, King's Bench. A very key decision, and in your free time, I would expect you to at least give your attention to some of these decisions. Now, it's a decision of 1910, and you find it in King's Bench. Now, I'm aware at this stage you may not be very sure, but each of the cases we shall be giving you has a principle which will need you to understand and has a principle which you as students need to appreciate better. Now, of course, we have cases like Wilmington versus DPP, a very key case which each and every student at first year, you need to be able to look at and appreciate. Wilmington versus DPP. Now, this is also a very old decision of 1932. You'll find it in 1932 appeal cases. Now, when I give you the names of the parties, I include the year the decision of the case was made. And I also include the law report in which that case is recorded. Now, this is just to show that cases are important. Now, I need to emphasize that in the normal setting, when probably in your walks of life, you realize that there isn't anything in criminal law that has no decision from courts of law. So cases are decisions which are made by courts of law. Let me also probably emphasize that courts of law give us these decisions, and the decisions vary. Some of the decisions are made by magistrate courts, which are the lowest courts, or crown courts if you look in other countries. But of course, in our context here in Uganda, we call them the magistrate courts. Above the magistrate courts, we have what we call the High Court, which we call Court of Judicature, and also have the Court of Appeal and the Supreme Court. So each of these particular courts makes a decision which is very important. And some of the decisions, not all, but some of them will be very vital, fundamentally vital for your reading of criminal law. Now, apart from that, I need to go to, that is source of criminal law number 2. We have source of criminal law number 3. So number 3, we are going to be looking at what we call the Acts of Parliament. Number 3, we have the Acts of Parliament. What basically do we mean by this? And when are they relevant, or why are they important as another source of criminal law? Okay. Now, when we talk about the Acts of Parliament, what you need to appreciate here is mainly, we have, these are mainly basically the enactments which are made by the Ugandan Parliament. Enactments, okay? And some books will refer to this as primary legislation. Now, in as far as criminal law is concerned, our special attention will be on the Penal Code Act. Now, there are very many different acts of parliament, but we are more interested in the Penal Code Act, which is probably the most important. It's the most important framework that we shall be giving attention. So in your free time, of course, even whenever you have an opportunity, try to look at the Penal Code Act. The Penal Code Act is a very vital legislation. It's vital because it has different sections. As you hear the word penal, meaning it comes from penal sanction, it's there to actually impose some form of punishment. So a Penal Code Act is very important, and we shall see sections from section 1 right at the very last section in the Penal Code Act. They are very, very important, and I will encourage you to look at them. Of course, during your first semester, we mainly give attention to some of the most relevant sections, like section 12 of that Penal Code Act. It's talking about, primarily it's giving emphasis on aspects such as intoxication, which is a defense. We shall cover defenses much later in one of the sections. And of course, there is section 19 and section 20. These are talking about parties to the crime, primary parties and secondary parties, things which you need definitely to appreciate in your first year. But all these are found in the Penal Code Act. I can't overemphasize the importance of that particular act. Now, of course, the fourth and the last example of the source of criminal law is what we call common law. The fourth and the last one is what we call common law. Now, this is also very important for you to appreciate where our legal history of common law emanates or comes from. And maybe to break it a little bit down, common law, we have principles of common law like what we call doli incapax. When we talk about doli incapax, that is something which I'll expect you in your free time to actually give attention to. And I'm going to explain this. Some of these are Latin phrases, but they have been adopted in common law. So doli incapax, it's a phrase basically which talks about the children. The children are not liable for their crimes. A 3-year-old, a 2-year-old child, if they get a knife and maybe throw it at you, you cannot take them to court. But that is, the word we use is doli incapax, meaning they are defended. But these are common law phrases. Another example of common law is what we call the Magnatan rules. The Manhattan rules. Now, these are rules of insanity, rules relating to insanity. Now, basically, of course, I'm aware that people who are of unsound mind, people who have mental illnesses are actually not supposed to suffer any form of liability. So that is also very vital in as far as our understanding of liability is concerned. So common law, clearly you can see I have demonstrated that it's one of the important and very important sources of criminal law. Now, we are done with the sources of criminal law. I'll take you to the next part of this discussion, which is basically the nature of criminal law. The next part of this discussion, I'm interested to explore the nature of criminal law, and that is probably what we are going to be looking at as probably part of the next discussion. The nature of criminal law is equally important, as we are yet to see. It is one of those particular aspects or attributes which helps you to appreciate criminal law really well, and we cannot probably think that we've covered criminal law until we have really covered this extensively. Now, we need also to understand the nature of criminal law. This is very vital. And in this regard, we are going to talk about primarily, roughly 6 areas. Of course, 1, retrospectivity. I'm going to explain that really, really well. We have what we call punitive nature of criminal law. I'm going to break it down. We have what we call uniformity of criminal law. But I think it's important for me to indeed add others which are not very common. There is what we call punitive nature. Criminal law is punitive, but its punitive nature, we shall link it to punishment. Punitive comes from punishment. So the moment we talk about punitive nature, we are talking about punishment. We will talk about retrospectivity. That means no one should be punished for a crime which at the time when they committed it, it wasn't a crime. At the time when they committed it, that act was not a crime. So here what we need to appreciate is that if maybe a law is made, let's say probably 2026, and the law maybe criminalizes any act, and say maybe stealing mangoes is bad, or that law says maybe using Facebook is bad. So that means that particular law will only begin applying after that year, 2026. And that's what we mean by retrospectivity. A very, very common area, but highly examinable as well. So you need to understand when we talk about the retrospective nature of criminal law, what exactly do we mean? So retrospectivity basically means that criminal law is one of those subjects which expects a criminal to be punished from the time the law has made an act unlawful. It's from that time onwards that you'll be held liable. Now, to that effect, in as far as retrospectivity is concerned, let me encourage you in your free time, read the case of Uganda versus Uganda. Uganda versus Uganda. That is a very useful case because in that case, principles of retrospectivity were extensively discussed. A useful Ugandan decision. The other aspect is punitive nature. It's basically punishment. Anyone who does something wrong, they should be punished. So criminal law is the only module which imposes punishment. Punishments are varied. We can talk about, of course, I'm aware, and with relative reservations, I'm aware that we have punishment like the death penalty, which are still very controversial, but we can still mention that it's one of the punishments which has ever lived in this world. But of course, in addition to that, to talk about punitive fine, you can be given a punitive fine. That is another aspect of a punishment. We shall get to see what kind of offenses are you likely to face a punitive fine. There is, of course, the most common one is imprisonment, sending you to jail. That is another key attribute of criminal law. Now, there are other relatively smaller actions which are punitive. There is what we call a caution. You can be given a caution, of course, and that is also another attribute of criminal law. So punitive means criminal law is there to punish, and it punishes in different ways, right from the caution all the way to probably a death penalty if the law provides for it. Now, of course, we are now going to talk about universality, uniformity, and purity of criminal law. Those are the other key important attributes which I think are equally important, and we need maybe to expound a little bit more on them. Now, first and foremost, I will talk about the universality. That means criminal law universally applies to everyone. Its university nature. It is expected that every person has to apply to criminal law, not just to a few. So this basically means it applies to everyone. Okay, everyone should comply with criminal law. So it has no regard or special respect to a person in relation maybe to their religion or in relation to their socio-economic status. So that makes criminal law very, very important. Now, the other attribute is uniformity. Criminal law is uniform. It applies to each and every person within a country. So that makes criminal law quite unique. So this basically means it applies to all individuals within a given location. You probably by now you should have realized that universality and uniformity, they seemingly related. They seem rather similar, and yet they are clearly different. Now, having exhausted that, I want to take you to the next part where I'm going to talk about the principles of criminal law. Having exhausted the discussion on the nature of criminal law, let's go further on, and we probably crown this discussion by looking at the principles of criminal law. That will probably be our last part of discussion for today, principles of criminal law, and then I'll probably take questions and see if there is anything you haven't understood. Okay? Principles of criminal law. There are mainly two. We have one, something called the actus reus, and what we call the mens rea. Now, the moment I talk about actus reus, I think it's very important for me to break down what do we mean by actus reus. Actus reus, basically here we are referring to actions. Actions. Not just actions, but unlawful. Actions which are unlawful in nature, okay? Unlawful actions, okay? So if you do anything unlawful, that act basically becomes criminal. That is where this comes from, okay? If you probably break in someone's house, what we call house breaking, if you probably rob someone's property or engage in theft, that is an act. By you taking away someone's phone, you realize that when I talk about some of the principles, I'm even going a little bit deeper in talking about the actions. Now, when we talk about actions, we talk of taking. For example, theft, there should be taking. You must take something belonging to another. You may realize I've said you must take something, okay? Some books may even add you must take something of value, okay, something of value. Of course, what you've taken must belong to another person, meaning it doesn't belong to you, okay? So it must belong to another person. Of course, very interesting questions have been risen in some books asking if you throw a pen away and someone picks, can you say that they have stolen it? If, for example, you throw shoes, you no longer need them, and you say, well, let them go to the rubbish pit. Someone picks the shoes, and then you find them putting them on. Will that person be a thief? So very interesting questions we may have to explore, but the property taken must belong to another. So every crime in criminal law has an actus reus. When we talk about murder, there should be a dead body. The dead body must have, the accused person must actually have caused the death of the victim. Now, those are what we're going to expound more, but what we need to understand that every criminal offense has an action. But of course, there are exceptions to this rule, as we are yet to see. We can also hold people liable in criminal law based on omissions. If the law requires you to do something and for some reason you don't do it, then you'll still be held liable. So the opposite of actus reus, we shall later see, is what we call omissions. You omit what you are expected to do, okay? You may be a security guard, employed and paid to actually take care of certain property. And then at night, you choose maybe to sleep and even drink. So the thieves come and they literally rob everything from the premises. So in the morning, they will say, well, we have checked on the CCTV, you were sleeping. So you failed to do what you are expected to do. So you omitted. So, but that is the exception. Majority of the criminal cases, we really focus on actions rather than omissions, okay? So from actions, the other brother to action is what we call intention, which is mens rea. Intention. Now, some books like Clarkson and Keating, Catherine Elliott, of course, books such as Smith and Hogan, which I will really encourage you to read, you find that when they talk about mens rea, they talk about the mental element. They talk about the mental element. Okay, mental element shows your intention. Now, I'm aware that in some textbooks they have said this is a relatively complex subject. How can you know that someone intended to do something? Now, there is some evidence we can rely on to say, well, that person intended to steal the property. If you pick a phone and you don't bother looking for its owner, but you even go a step further, you try to change its case or its appearance, that shows you are intending to steal it. So mens rea is the intention, okay? While on the other side, we have the act of you taking, and then thereafter, the process of you trying to change someone's property to look differently so that the owner doesn't recognize it. That is what we call the intention. And in criminal law, lawyers will normally say mens rea. So in this class, you must be able to understand that every criminal case, we shall have the actus reus. Maybe this is a formula which you probably have to bear in mind, plus mens rea, actus reus from plus the mens rea. Then this will give us the crime. Actus reus from the mens rea is equal to crime. That is going to be the golden rule as far as this particular topic is concerned. Of course, we shall say exceptions, omissions. These are offenses where you have not done what you're supposed to do. We have offenses of strict liability. We also have other relatively unique offenses of corporate liability, what we call liability of entities which are corporations. But those are aspects we shall be covering and going into details as we proceed in the subsequent seminars. Now, that definitely marks the end of this discussion. Thank you for listening and thank you for your attention. Any thoughts, any suggestions, any questions are very welcome. Thank you very much.